So I've already read the first 3 pages of this case. There's 9 more. I'm going to read the first 3 pages again. I'm going to try to get through it, even though it's very difficult material. Justice Kennedy delivered the opinion of the court in this case, except as to Part 2B. Various federal courts of appeals are divided over the evidence question presented by this case. At issue is the interpretation of a provision in the federal rules of evidence bearing upon the admissibility of statements made by a declarant who testifies as a witness that are consistent with the testimony and are offered to rebut a charge of a recent fabrication or improper influence or motive. Giving the citation Federal Rule of Evidence 801D1B, the question is whether out-of-court consistent statements made after the alleged fabrication or after the alleged improper influence or motive arose are admissible under this rule. Part 1, Petitioner Tome was charged in a 1-count indictment with the felony of sexual abuse of a child, his own daughter, age 4 at the time of alleged crime. The case having arisen on the Navajo Indian Reservation, Tome was tried by a jury in the United States District Court for the District of New Mexico, where he was found guilty of violating 18 U.S.C. 1153, 2241C and 2245A and B. Tome and the child's mother had been divorced in 1988. A tribal court awarded joint custody of the daughter AT to both parents, but Tome had primary physical custody. In 1989, the mother was unsuccessful in petitioning the tribal court for primary custody of AT, but was awarded custody for the summer of 1990. Neither parent attended a further custody hearing in August 1990. On August 27th of 1990, the mother contacted Colorado authorities with allegations that Tome had committed sexual abuse against AT. The prosecution's theory was that Tome committed sexual assaults upon the child while she was in his custody and that the crime was disclosed when the child was spending vacation time with her mother. The defense argued that the allegations were concocted so the child would not be returned to the father. At trial, AT, then 6.5 years old, was the government's first witness. For the most part, her direct testimony consisted of 1- and 2-word answers to a series of leading questions. Cross-examination took place over 2 trial days. The defense asked AT 348 questions. On the first day, AT answered all the questions posed to her on general background subjects. The next day, there was no testimony, and the prosecutor met with AT. When cross-examination of AT resumed, she was questioned about those conversations, but was reluctant to discuss them. Defense counsel then began questioning her about the alleged allegations of abuse, and it appeared she was reluctant at many points to answer. As the trial judge noted, however, some of the defense questions were imprecise or unclear. The judge expressed his concern with the examination of AT, observing there were lapses of as much as 40 to 55 seconds between some questions and the answers, and that on the second day of examination, the witness seemed to be losing concentration. The trial judge stated, "We have a very difficult situation here." After AT testified, the government produced 6 witnesses who testified about a total of 7 statements made by AT describing the alleged sexual assaults. AT's babysitter recited AT's statement to her on August 22nd of 1990 that she did not want to return to her father because he gets drunk and he thinks I'm his wife. The babysitter related further details given by AT on August 27th, 1990, when AT's mother stood outside the room. And so this is like August 22nd, August 27th. That's surprisingly close to when they were supposed to go back to custody hearing. They missed it, and then they brought this action on the 27th. While AT's mother stood outside the room and listened after the mother had been unsuccessful in questioning AT herself. A social worker recounting details AT told her on August 29, 1990 about the assaults, and 3 pediatricians, Dr. Cooper, Reich, and Spiegel, related AT statements to them describing how and where she had been touched by Tome. All but AT's statement to Dr. Spiegel implicated Tome. The physicians also testified that their clinical examinations of the child indicated that she had been subjected to vaginal penetrations. That part of the testimony is not an issue here. AT's out-of-court statements recounted by the 6 witnesses were offered by the government under Rule 801 D1B. The trial court admitted all of the statements over defense counsel's objection, accepting the government's argument that they rebutted the implicit charge that AT's testimony was motivated by a desire to live with her mother. The court also admitted AT's August 22nd statement to her babysitter under Rule 803-24 and the statements to Dr. Cooper and apparently also to Dr. Wright under Rule 803-D. Statements for purposes of medical diagnosis. The government offered the testimony of the social worker under both 801 D1B and 803-24, but the record does not indicate whether the court ruled on the latter ground. No objection was made to Dr. Spiegel's testimony. Following trial, Tome was convicted and sentenced to 12 years imprisonment. On appeal, the Court of Appeals for the 10th Circuit affirmed, adopting the government's argument that all of AT's out-of-court statements were admissible under Rule 801 D1B, even though they had been made after AT's alleged motive to fabricate arose. The court reasoned that the pre-motive requirement is a function of the relevancy rules, not the hearsay rules, and that as a function of relevance, the pre-motive rule is clearly too broad because it is simply not true that an individual with a motive to lie always will do so. Rather, the relevance of the prior consistent statement is more accurately determined by evaluating the strength of the motive to lie, the circumstances in which the statement is made, and the declarant demonstrated propensity to lie. Applying this balancing test to AT's first statement to her babysitter, the Court of Appeals determined that although AT might have had some motive to lie, the district judge had not abused his discretion in admitting AT's out-of-court statements. It did not analyze the probative quality of AT's 6 other out-of-court statements, nor did it reach the admissibility of the statements under any other rule of evidence. We granted certiorari and now reverse. Part 2. The prevailing common law rule for more than a century before adoption of federal rules of evidence was that a prior consistent statement was introduced to rebut a charge. Let me read this because this is the actual common law. Mess this up. The prevailing common law rule for more than a century before adopted by the federal rules of evidence was that a prior consistent statement introduced to rebut a charge of recent fabrication or improper influence or motive was admissible if the statement had been made before the alleged fabrication, influence, or motive came into being, but it was inadmissible if made afterwards. As Justice Story explained, where the testimony is assailed as a fabrication of a recent date, in order to repel such imputation, proof of the antecedent declaration of the party may be omitted. Citing Ellicott v. Pearl, emphasis added, see also People v. Singer, New York, 1949. McCormick and Wigmore stated the rule in a more categorical manner. The applicable principle is that the prior consistent statement has no relevancy to refute the charge unless the consistent statement was made before the source of the bias, interest, influence, or incapacity originated. McCormick on Evidence, Section 49, page 105, 1972, hereafter McCormick. See also Wigmore Evidence, Section 1128, 1972, hereafter Wigmore. A consistent statement at a time prior to the existence of a fact said to indicate bias will effectively explain away the force of the impeaching evidence, emphasis in original. One question is whether Rule 801 D1B embodies a temporal requirement. We hold that it does. Rule 801 defines prior consistent statements as non-hearsay only if they are offered, and this is consistent statements, only if they are offered to rebut a charge of recent fabrication or improper influence or motive. Again, giving the same citation. Nothing the troublesome logic of treating noting the troublesome logic of treating a witness's prior consistent statements as hearsay at all, because the declarant is present in court and subject to cross-examination. The advisory committee decided to treat those consistent statements once the preconditions of the rule were satisfied as non-hearsay and admissible as substantive evidence, not just to rebut an attack on the witness's credibility. See Advisory Committee's notes on Federal Evidence 801D1. A consistent statement meeting the requirements of the rule is thus placed in the same category as a declarant's inconsistent statement made under oath in another proceeding or prior identification testimony or admissions by a party opponent. So it's like analogous. The rules do not accord this weighty non-hearsay status to all prior consistent statements. To the contrary, admissibility under the rules is confined to the statements afforded to rebut a charge of recent fabrication or improper influence or motive. This same phrase, used by the advisory committee in its description of the traditional common law, quote, in quotes, common law of evidence, which was the background against which the rules were drafted. Prior consistent statements, may not be admitted to counter all forms of impeachment or to bolster the witness merely because she has been discredited. In the present context, the question is whether AT's out-of-court statements rebuted the alleged link between her desire to be with her mother and her testimony, not whether they suggested that AT's in-court testimony was true. The rule speaks of a party rebuting an alleged motive, not bolstering the veracity of the story told. This limitation is instructive, not only to establish the preconditions of admissibility, but also to reinforce the significance of the requirement that the consistent statements must have been made before the alleged influence or motive to fabricate arose. That is to say, the forms of impeachment within the rule's coverage are the ones in which temporal requirement makes the most sense. Impeachment by charging that the testimony is a recent fabrication or results from an improper influence or motive is, as a general matter, capable of direct and forceful refutation through introduction of out-of-court consistent statements that predate the alleged fabrication, influence, or motive. A consistent statement that predates the motive is a square rebuttal of the charge that the testimony was contrived as a consequence of that motive. By contrast, prior consistent statements carry little rebuttal force when most other types of impeachment are involved. McCormick, Section 49-105, when the attack takes the form of impeachment of character by showing misconduct, convictions, or bad reputation, it is generally agreed that there is no color for sustaining but consistent statements, period. The defense does not meet the assault, footnote omitted. See also for Wigmore, section 1131, page 293. The broad rule obtains in a few courts that consistent statements may be admitted after impeachment of any sort, in particular after any impeachment by cross-examination. But there is no reason for such a loose rule, footnote omitted. There may arise instances when out-of-court statements that post-date the alleged fabrication have some probative force in rebuting a charge of fabrication or improper influence or motive, but those statements refute the charged fabrication in a less direct and forceful way. Evidence that a witness made consistent statements after the alleged motive to fabricate arose may suggest to some degree that the in-court testimony is truthful, and thus suggest in some degree that the testimony did not result from some improper influence. But if the drafters of Rule 801 D1B intended to countenance rebuttal along that direct inferential chain, the purpose of confining the types of impeachment that open the door to rebuttal by introducing consistent statements becomes unclear. If consistent statements are admissible without reference to the time frame, we find embedded in the rule where appears no sound reason not to admit consistent statements to rebut other forms of impeachment as well. Whatever objections can be leveled against limiting the rule to this designated form of impeachment and confining the rebuttal to those statements made before the fabrication or improper influence or motive arose. It is clear to us that the drafters of Rule 801 D1B were relying upon the common law temporal requirement. The language of So again, this is the intent. The language of the rule, in its concentration on rebuting charges of recent fabrication or improper influence or motive to the exclusion of other forms of impeachment, as well as in its use of wording that follows the language of the common law cases, suggests that it was intended to carry over the common law pre-motive rule. Part B of Part 2. Our conclusion that Rule 801 D1B embodies the common law pre-motive requirement is confirmed by an examination of the Advisory Committee's notes to the Federal Rules of Evidence. We have relied on those well-considered notes as a useful guide in ascertaining the meaning of the rule. See Huddleston v. United States v. Owens. Whereas with Rule 801 D1B, Congress did not amend the Advisory Committee's draft in any way, the committee's commentary is particularly relevant in determining the meaning of the document Congress enacted. Beach Airway Corp. v. Rainey. The notes are also a respected source of scholarly commentary. Professor Cleary was a distinguished commentator on the law of evidence, and he and members of the committee consulted and considered the views, criticisms, and suggestions of the academic community in preparing the notes. The notes disclose a purpose to adhere to the common law in the application of evidentiary principles, absent express provisions to the contrary, period. Where the rules did depart from their common law antecedents, in general, the committee said so. See example notes on Rule 804B4, the general common law requirement that a declaration in this area must have been made ante litem motum has been dropped as bearing more appropriately on weight than admissibility. Rule 804B2. So these are examples of explicit departures from the common law. In 804B2, the exception is the familiar dying declaration of the common law expanded somewhat beyond traditionally narrow limits. 804B3, the exception discards the common law limitation and expands to the full logical limit. The notes give no indication, however, that Rule 801 D1B abandoned the pre-motive requirement. The entire discussion of 801 D1B is limited to the following comment. Reading as follows. Prior consistent statements traditionally have been admissible to rebut charges of recent fabrication or improper influence or motive, but not as substantive evidence. Under the rule, they are substantive evidence. The prior statement is consistent with the testimony given on the stand, and if the opposite party wishes to open the door for its admission in evidence, no sound reason is apparent why it should not be received generally. Throughout their decision of the rules, the Advisory Committee's notes rely on Wigmore and McCormick as authority for the common law approach. In light of the categorical manner in which those authors state the pre-motive requirement, it is difficult to imagine the drafters who noted the new substantive use of prior consistent statements would have remained silent if they intended to modify the pre-motive requirement. As we observed with respect to another provision of the rules, with its state of unanimity, confronting the drafters of the Federal Rules of Evidence, we think it unlikely that they intended to scuttle entirely the common law requirement from U.S. v. Abel, 1984. Here, we do not think the drafters of this rule intended to scuttle the whole pre-motive requirement and rationale without so much as a whisper of explanation. Observing that Edward Cleary was a reporter of the Advisory Committee that drafted the rules, the court has relied upon his writings as persuasive authority on the meaning of the rules. See Dobert v. Merrill, Dow Pharmaceuticals of 1983, and Abel, Supra 51 through 52. Cleary was also was responsible for the 1972 revision of McCormick's treatise, which included an examination of the changes introduced by the proposed federal rules to the common law practice of impeachment and rehabilitation. The discussion, which occurs only 3 paragraphs after the treaty's categorical description of the common law pre-motive rule, also lacks any indication that the proposed rules were banning the temporal limitation. See McCormick, section 50, page 107. Our conclusion is bolstered by the advisory committee's stated unwillingness to countenance the general use of prior prepared statements as substantive evidence. See notes on Rule 801D1, Rule 801D, which enumerates 3 situations in which the statement is accepted from the category of hearsay, which was expressly contrasted by the committee with Uniform Rule of Evidence 63, 1953, which allows any out-of-court statement of a declarant who is present at a trial and available for cross-examination. When a witness presents important testimony damaging to a party, did I finish that? Yeah. Notes on Rule 801D1, emphasis added. When a witness presents important testimony damaging to a party, the party will often counter with at least an implicit charge that the witness has been under some influence or motive to fabricate. If Rule 801 were read so that the charge opened floodgates to any prior consistent statement that satisfied Rule 403, as the 10th Circuit concluded, the distinction between rejected Uniform Rule 63.1 and Rule 801D1B would all but disappear. That Rule 801D1B permits prior consistent statements to be used for substantive purposes after these statements are admitted to rebut the existence of an improper influence or motive, makes it all the more important to observe the preconditions for admitting the evidence in the first place. The position taken by the rules reflects a compromise between the rules expressed by the bulk of the case law against allowing prior statements of witnesses to be used generally as substantive evidence, and the views of the majority of writers who had taken the opposite position. That compromise was one that the committee candidly admitted was a judgment more of experience than of logic. A party contending that legislative action change settled law has the burden of showing that the legislator intended such a change. I feel like that's a new concept. From Green vs. Bach, Laundry Machine Co., 1989. Applying that presumption of interpreting Federal Rule of Evidence 609. Nothing in the advisory committee's notes suggested intended to alter the common law pre-motive requirement. So that, again, is the holding on issue number 2. Part C of Part 2. The government's final argument in favor of affirmance is that the common law promotive rule advocated by petitioner is inconsistent with the federal rule's liberal approach to relevancy and with strong academic criticism beginning in 1940s directed at the exclusion of out-of-court statements made by the declarant who is present in court and subject to cross-examination. This argument misconceives the design of the rule's hearsay provisions. Hearsay evidence is often relevant. That certain out-of-court statements may be relevant does not dispose of the question whether they are admissible. To be sure, certain commentators in the years preceding the adoption of the rule had been critical of the common law approach to hearsay, particularly in its categorical exclusion of out-of-court statements offered for substantive purposes. General criticism was directed to the exclusion of the declarant's out-of-court statement where the declarant testified at trial. As an alternative, they suggested moving away from the categorical exclusion of hearsay and toward a case-by-case balancing of the probative value of particular statements against their likely prejudicial effect. The advisory committee, however, was explicit in rejecting this balancing approach to hearsay. The advisory committee has rejected this approach to hearsay as involving too great a measure of judicial discretion, minimizing the predictability of rulings and enhancing the difficulties of preparation for trial. Advisory Committee's introduction to Article 8. The statement-by-statement balancing approach advocated by the government and adopted by the 10th Circuit creates a precise dangers the advisory committee noted and sought to avoid. It involves considerable judicial discretion, it reduces predictability, and it enhances the difficulties of trial preparation because parties will have difficulty knowing in advance whether or not particular out-of-court statements will be admitted. Part D of Part 2, this case before us, illustrates some of the important considerations supporting the rule as we interpret it, especially in criminal cases. If the rule were to permit the introduction of prior statements as substantive evidence to refute every implicit charge that a witness in court testimony results from the recent fabrication or improper influence or motive, the whole emphasis of the trial would shift to the out-of-court statements, not the in-court ones. The present case illustrates the point. In response to a rather weak charge that AT's testimony was a fabrication created so the child could remain with her mother, the government was permitted to present a parade of sympathetic and credible witnesses who did no more than recount AT's detailed out-of-court statements to them. Although the statements might have been probative on the question whether the alleged conduct had occurred, they shed but minimal light on whether AT had the charged motive to fabricate. At closing argument before the jury, the government placed a great reliance on the prior statements for substantive purposes, but did not seek to use them to rebut the impact of the alleged motive. We are aware that in some cases it may be difficult to ascertain when a particular fabrication, influence, or motive arose. Yet, as the government concedes, a majority of common law courts were performing the task for well over a century, and the government has presented us with no evidence that those courts or the judicial circuits that adhere to the rule today have been unable to make the determination. Even under the government's hypothesis, moreover, the thing to be rebutted must be identified, so the date of the origin cannot be that much more difficult to ascertain. By contrast, as the advisory committee commented, the government's approach, which would require the trial court to weigh all the circumstances surrounding a statement that suggests its probativeness against the court's assessment of the strength of the alleged motive, would entail more of a burden, but no guidance to attorneys in preparing the case or to the appellate courts in reviewing a judgment. Part 3. Courts must be sensitive to the difficulties attendant upon the prosecution of alleged child abusers. In all cases, a youth is the prosecution's only eyewitness, but this court cannot alter evidentiary rules merely because the litigants might prefer different rules in a particular class of cases. United States v. Salerno, 1992. When a party seeks to introduce out-of-court statements that contain strong circumstantial indicia of reliability that are highly probative on the material questions at trial and that are better than other evidence otherwise available, there is no need to distort the requirements of Rule 801 D1B. If its requirements are met, Rule 803-24 exists for that eventuality. We intimate no view, however, concerning the admissibility of any of AT's out-of-court statements under the section or any other evidentiary principle. These matters and others are for the Court of Appeals to decide in the first instance. Our holding is confined to the requirements for admission under Rule 801 D1B. The rule permits the introduction of a declarant's consistent out-of-court statements to refute a charge of recent fabrication or improper influence or motive only when those statements were made before the charged recent fabrication or improper influence or motive. These conditions of admissibility are not established here. The judgment of the Court of Appeals for the 10th Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. Justice Scalia, concurring in part and concurring in the judgment, is only about a half page. Breyer, with whom the Chief Justice O'Connor and Thomas joined dissenting, is the following 2.5 pages. So we're going to start with the concurring and dissenting opinions now. Scalia, I concur in the judgment of the court and join its opinion except for Part 2B, that part which is devoted entirely to a discussion of the advisory committee notes pertinent to Rule 801D1B, gives effect to those notes not only because they are a respected source of scholarly commentary, but also because they display the purpose or intent of the draftsman. I had previously acquiesced in C. Example Beach Aircraft Corp. v. Rainey of 1988, and indeed myself engaged in C. United States v. Owens, 1988, similar use of the advisory committee notes. More mature consideration has persuaded me that it is wrong. Having been prepared by a body of experts, the notes are assuredly persuasive scholarly commentaries, ordinarily the most persuasive concerning the meaning of the rules, but they bear no special authoritativeness as the work of the draftsman, any more than the views of Alexander Hamilton, the draftsman, bear more authority than the views of Thomas Jefferson, not a draftsman, with regard to the meaning of the Constitution. It is the words of the rules that have been authoritatively adopted by this court or by Congress. It is, if it makes a statutory change, see 28 U.S.C. section 2072 and 2074 of 1988 edition, sub 4. In my view, even the adopting justice's thoughts, unpromulgated as rules, have no authoritative as opposed to persuasive effect, any more than their thoughts regarding an opinion, reflected in exchanges of memoranda before the opinion issues, authoritatively demonstrate the meaning of that opinion, and the same for the thoughts of congressional draftsmen who prepare statutory amendments to the rules. Like a judicial opinion and like a statute, the promulgated rule says what it says, regardless of the intent of the drafters. The notes are, to be sure, submitted to us and to the members of Congress as the thoughts of the body initiating the recommendations. See Section 2073D, but there is no certainty that either we or they read those thoughts, nor is there any procedure by which we formally endorse or disclaim them. That being so, the notes cannot, by some power inherent to the draftsman, change the meaning that the rules would otherwise bear. Breyer, the Chief Justice, O'Connor, and Thomas joined dissenting. The basic issue in this case concerns not hearsay but relevance. As the majority points out, the common law permitted a lawyer to rehabilitate a witness after a charge of improper motive by pointing to the fact that the witness had said the same thing earlier, but only if the witness made the earlier statement before the motive to lie arose. The majority believes that a hearsay-related rule, Federal Rule of Evidence 801 D1B, codifies this absolute timing requirement. I do not. Rule 801 D1B has nothing to do with relevance. Rather, that rule carves out a subset of prior consistent statements that were formally admissible only to rehabilitate a witness, a non-hearsay use that relies upon the fact that a statement was made. It then says that members of that subset are not hearsay. This means that if such a statement is admissible for a particular rehabilitative purpose to rebut a charge of recent fabrication or improper influence or motive, its proponent now may use it substantively for a hearsay purpose, i.e., as evidence of its truth as well. One can find a hearsay-related reason for why the drafters might have decided to restrict the rule to a particular category of prior consistent statements. Juries have trouble distinguishing between the rehabilitative and substantive use of the kind of prior consistent statements listed in Rule 801 D1B. Judges may give instructions limiting the use of such prior consistent statements to a rehabilitative purpose, but in practice, juries nonetheless tend to consider them for their substantive value. It is possible that the advisory committee made them non-hearsay for that reason, i.e., as a concession more of experience than of logic. Advisory committee notes on Federal Rule 801 D1B, also noting that the witness is available for cross-examination in the courtroom in any event. If there was a reason why the drafters excluded from the rule scope other kinds of prior consistent statements used for rehabilitation, perhaps it was that the drafters concluded that those other statements caused jury confusion to a lesser degree. On this rationale, however, there is no basis for distinguishing between pre-motive and post-motive statements. for the confusion with respect to each would very likely be the same. I would read the rules plain words to mean exactly what they say. If a trial court properly admits a statement that is consistent with the declarant's testimony for the purposes of rebutting an express or implied charge, of recent fabrication or improper influence or motive, then that statement is not hearsay, and the jury may also consider it for the truth of what it says. Yeah, so like there's no temporal requirement in that statement. What that statement means, we've been talking about. Assuming Rule 801 D1B does not codify the absolute timing requirement, I must still answer the question whether, as a relevance matter, the common law statement of the pre-motive rule stands as an absolute bar to the trial court's admission of a post-motive prior consistent statement for the purpose of rebutting a charge of recent fabrication or improper influence or motive. I don't understand that. The common law statement of the pre-motive rule stands as an absolute bar to the trial court's admission of a post-motive prior consistent statement for the purpose of rebutting a charge of recent fabrication or improper influence or motive. There are sound reasons here for permitting an exception to the timing rule where circumstances warrant. For one thing, one can find examples where the timing rule's claim of no relevancy is simply untrue. A post-motive statement is relevant to rebut, for example, a charge of recent fabrication based on improper motive, say, when the speaker made the prior statement while affected by a far more powerful motive to tell the truth. A speaker might be motivated to lie to help an acquaintance, but suppose the circumstances also make clear to the speaker that only the truth will save his child's life, or suppose a post-motive statement was made spontaneously or when the speaker's motive to lie was much weaker than it was at trial. In these and similar situations, special circumstances may indicate that the prior statement was made for some reason other than the alleged improper motivation. It may have been made not because of, but despite the improper motivation. Hence, the post-motive statements can, in appropriate circumstances, directly refute the charge of fabrication based on improper motive, not because they bolster in a general way the witnesses or trial testimony, but because the circumstances indicate that the statements are not causally connected to the alleged motive to lie. Trial judges may find it easier to administer an absolute rule, yet there is no indication in any of the cases that trial judges would, or do, find it particularly difficult to administer a more flexible rule in this context. And there is something to be said for the greater authority that flexibility grants the trial judge to tie rulings on the admissibility of rehabilitative evidence more closely to the needs and circumstances of the particular case. Furthermore, the majority concedes that the pre-motive rule, while seemingly bright line, poses its own administrative difficulties. This court has acknowledged that the federal rules of evidence worked a change in common law relevancy rules in the direction of flexibility. See Daubert v. Merrill Dow Pharmaceuticals of 1983. Article 4 of the federal rules, which concerns relevance, liberalizes the rules for admission of relevant evidence. The rules direct the trial judge generally to admit all evidence having any tendency to make the existence of fact more probable or less probable than would be without the evidence. Federal Rules 401, 402, period. The judge may reject the evidence, assuming compliance with other rules, only if the probative value of the evidence is substantially outweighed by a tendency to prejudice a party or delay a trial. Rule 403. The codification, as a general matter, relies upon the trial judge's administration of rules 401, 402, and 403 to keep the barely relevant and time-wasting and and the prejudicial from the jury. Perhaps there are other circumstances in which categorical common law rules serve the purposes of Rules 401, 402, and 403 and should, accordingly, remain absolute in the law. But for the reasons stated above, this case, like Daubert, does not present such circumstance. Thus, considered purely as a matter of relevancy law, and as though Rule 801D1B had not been written, I would conclude that the premotive rule did not survive the adoption of the rules. Accordingly, I would hold that the federal rules authorize a district court to allow, where probative in respect to rehabilitation, the use of postmotive prior consistent statements to rebut a charge of recent fabrication or improper influence or motive, subject to, of course, to, for example, Rule 403, where such statements are admissible for this rehabilitative purpose. Rule 801D1B, as stated above, makes them admissible as substantive evidence as well, provided, of course, that the rule's other requirements, such as the witness's availability for cross-examination, are satisfied. In most cases, this approach will not yield a different result from a strict adherence to the premotive rule, for in most cases, postmotive statements will not be significantly probative, and even in cases where the statement is admitted as significantly probative, in respect to rehabilitation, the effect of admission on the trial will be minimal because the prior consistent statements will, by their nature, do more than repeat in court testimony. In this case, the Court of Appeals, applying an approach consistent with what I have described above, decided that AT's prior consistent statements were probative on the question of whether her story as a witness reflected a motive to lie. There is no reason to reevaluate this fact-bound conclusion. Accordingly, I would inform the judgment of the Court of Appeals. So, after this, you see an amendment to FRE801 and the corresponding advisory committee note dated 2014. Though the original Rule 801D1B provided for substantive use of certain prior consistent statements, the rule covered only those consistent statements that were offered to rebut charges of recent fabrication or improper motive or influence. The rule did not, for example, provide for substantive admissibility of consistent statements that are probative to explain what otherwise appears to be an inconsistency in the witness's testimony. In order to cover consistent statements that would be probative to rebut a charge of faulty memory. Thus, the rule left many prior consistent statements potentially inadmissible only for the limited purpose of rehabilitating a witness's credibility. So, that's ultimately what is the intent. The original rule also led to some conflict in the cases. Some courts distinguished between substantive and rehabilitative use for prior consistent statements, while others appeared to hold that prior consistent statements must be admissible under Rule 801D1B or not at all. The amendment retains the requirements set forth in TOME verse, so it's consistent with the case the amendment is consistent with the case we just read. That under 801D1B, a consistent statement offered to rebut the charge of recent fabrication or improper influence or motive must have been made before the alleged fabrication or improper inference or motive arose. The intent of the amendment is to extend substantive effect to consistent statements that rebut other attacks on a witness, such as the charges of inconsistency or faulty memory. The amendment does not change the traditional and well-accepted limits on bringing prior consistent statements before the fact finder for credibility purposes. It does not allow impermissible bolstering of a witness. As before, prior consistent statements under the amendment may be brought before the fact finder only if they properly rehabilitate a witness whose credibility has been attacked. As before, to be admissible for rehabilitation, a prior consistent statement must satisfy the strictures of Rule 403. As before, the trial court has ample discretion to exclude prior consistent statements that are cumulative accounts of an event. The amendment does not make any consistent statement admissible that was not admissible previously, and the only difference is that prior consistent statements otherwise admissible for rehabilitation are now admissible substantively as well. So that's going to conclude the chapter on impeachment and rehabilitation.